Shifting our focus to the United States, where former President Donald Trump has called on the country's Supreme Court to review a Colorado ruling that bars him from the state's ballot over his role in the January 6, 2021 Capitol riots. Trump has also appealed a similar decision by Maine's Democratic Secretary of State. If the ruling is allowed to stand, it will be the first time in the history of the United States that the judiciary has prevented voters from casting ballots for the leading major party presidential candidate. The Colorado Supreme Court had ruled last month that Trump is ineligible to appear on the primary ballot because of the United States Constitution's 14th Amendment. Section 3 of the 14th Amendment bars anyone from holding public office if they engage in quote-unquote insurrection or rebellion. This after once pledging to support and defend the Constitution. Lawyers for the former Republican president have asked the Supreme Court to agree to hear the case and summarily reverse the court's ruling.
The appeal to the U.S. Supreme Court is especially significant because the nation's highest court has never before ruled in a case involving Section 3 of the 14th Amendment. That's a Civil War era provision that says that if you swore an oath to support the Constitution and then engaged in insurrection, you no longer are qualified for office.
Similar 14th Amendment challenges Trump's ineligibility have been filed in other states as well. Courts in Minnesota and Michigan recently ruled that Trump should stay on the ballot in those states. Maine and Colorado contest to elect their party presidential nominees on March 5th, also known as Super Tuesday, when voters in more than a dozen states, including California and Texas, go to polls.